and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know your lane for what you saying, yo. Silly with my 9 million with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, I be while in the studio. You don't wanna vibe, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap you with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you take it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my party to me. Fuck me, see what you got for me. Put more than fans with my eyes to see. Still $1 in a place to be. If you really my party to me. Fuck me, see what you got for me. Put more than fans with my eyes to see. Still $1 in a place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my party to me. Fuck me, see what you got for me. Put more than fans with my eyes to see. Still $1 in a place to be. If you really my party to me. Fuck me, see what you got for me. Put more than fans with my eyes to see. Still $1 in a place to be. If you really my party to me. Fuck me, see what you got for me. Put more than fans with my eyes to see. Still $1 in a place to be. If you really my party to me. Fuck me, see what you got for me. Put more than fans with my eyes to see. Still $1 in a place to be. If you.
Here comes the pitch, and it comes in wide. On the Donnell.
Hello, hello, hello. Good afternoon once again, everyone. Microphone check. This is a microphone check. 1, 2, 1, 2. Give me a thumbs up if you hear me loud and clear. Thank you.
Chris, what happened? You were right, Mr. Herbert. Franz is a Nazi, and he's keeping us prisoners down here. Get help.
All right. Thank you, guys. Thank you. You hear me good. Okay. Well, something came in from Pacer today for Don Russell. Remember, guys, we've been waiting for to hear about his Curcio hearing. Let me say what's up to everybody in the building while everybody's still climbing in here. Hello, cool gamer. Hello once again. Good to see you, buddy. Hey, Jennifer. What's up, mama? Shay Love. What's up, lady? How are you, mama? This 504. What's up, lady? Queen. What's up, baby? T-Bam. Hello, hello, hello. I'm eating some Lifesaver gummies. Hey, Kayla. What's up, mommy? These things are so good. Right. I'm just going to grab a couple more. While you guys are still climbing in here. Hey, fat boy. What's up, my papito baby boy? Mm, mm. I bit my cheek again. I cannot. So, guys, as I was saying, we know that Don Russell. Okay, Rockin', what's up, mama? I got you, baby. Always working. Always working. That's my lady. Listen, Don Russell, as we know, has been waiting for his Curcio hearing. And I believe it was supposed to be scheduled for, um, it was supposed to be May 19th. I believe it's supposed to be May 19th. So we got in paperwork today about it. So let me add that to the stream. Okay. And we're going to see what's going on with Don Russell. You hungry, baby? Here. I got lifesaver gummies. I actually have a a roast beef cooking in the oven, and I'm gonna do baked potato, loaded baked potato. Yes, some sour cream, some cheese, some bacon on top. That's what we're doing. Hey, Tasha. What's up, mama? What's up, Indigo? We're back, and we talking about Don Russell now. Yes, girl, I'm eating roast beef. I don't mind eating a little roast beef. 504. I don't mind. You know what I mean. Wink, wink. A little roast beef don't hurt nobody, girl. Ooh, that sounds interesting, Tasha. I think I just might do that, girl. Yo, Calais. Calais. What's up, bro? I love it. Cool gamer. Are you a boy or a girl? Please let me know. Because for a long time, my people's love is fair. I thought it was a female. For a very long time, I thought it was a girl. I was always saying, mommy, mommy, mommy. Until one day he was like, yo, just to let you know, I'm not a girl, I'm a boy. That was funny. I was like, oh my God, like, how did he let me do this all this time? So cool, gamer. Let me know if you're a boy or a girl up in the chat. Hey, Ty, what's up, baby? Girl, we got some paperwork on Don Russell today. Yes, we did. Peter, what's up, lady? We eat roast beef sandwiches, fully dressed. Yes, ma'am. Too strong, warrior. Warrior. What's up, my love? You meant po' boys. Okay. All right. So now, matter of fact, let me get a little water. Let me get my little water. I got my water here. I got my lifesavers. What's up, Candy? So, all right. I'm going to roll off a screen, but I got my phone. It is being charged. It's in front of my face. So, in case if I look down and I get a question or something. Okay. All righty. So, this is the United States versus Donnell Russell. 20 CR 538. And it says, Dear Judge Garden Fee. Gardy Fee. Gardefee. I'm so chopping up this honorable judge's name. Oh my God. Please excuse the pronunciation. Gardefee. Judge Gardefee. The government, okay, so as we see, this is a letter from the government. Okay. The government respectfully submits this letter to request a hearing pursuant to United States versus Curcio with respect to Michael Friedman's client, Donnell Russell. Now, as we know, Michael Friedman was going to represent R. Kelly in his Eastern District of New York trial. They were in negotiations, okay? And R. Kelly never retained him or hired him to be his lawyer. But he did have conversations with R. Kelly. So there's a client lawyer privilege there, right? So that's part of an issue because Michael Friedman was now retained by Donnell Russell. So Michael Friedman is going to be representing Donnell Russell in the Eastern District of New York charges for what he did with the Lifetime that he tried to put in a threat on Lifetime, as well as violating everything he violated. Like, he did a lot of dumb shit. I can't remember everything, but we will go through it here. So for his charges, for intimidation of victims, which we all know is Faith Rogers, that he put her out there on this Surviving Lies page on Facebook, exposed her pictures, text messages. He had what's her name, Cash Jones and Michael Williams approach Faith in a Applebee's restaurant. Also, he called and made a threat to the theater where they were doing the premiere of Surviving R. Kelly, Part 1. And so he got caught up for all this stuff. So he's being charged with intimidation and I forgot what else it is exactly. But basically for intimidating witnesses, you know. So that's what's going on. So, as set forth below, a potential conflict arises from Mr. Friedman's prior discussions with a prospective client who ultimately did not retain Mr. Friedman. So, on or about March 11, 2020, the defendant was charged by complaint with violating 18 U.S.C. 371 875C and 2, which relate to the defendant's threatening physical harm by interstate communication. On or about October 8th of 2020, a grand jury sitting in the district returned an indictment charging the defendant with the same offenses. On or about October 8th of 2020, a grand jury in the Eastern District of New York returned an indictment charging the defendant with interstate stalking in violation of 18 U.S.C. 2261A to B. See United States versus Donnell Russell, 20 CR 427, Eastern District of New York. So he's being charged with threatening physical harm by interstate communication, okay, which is where he made the phone call and to put the threat into the theater, right? As well as charging him with stalking interstate stalking. Okay. And that's because he was doing that bull crap with the Instagram with Richard Arline and threatening Lizette Martinez, Azriel Clary, and all of that. I showed you guys those text messages because we were put into those text messages. We were added into those, not text messages, DM messages. It was a bunch of us that was tagged in there. Me, Blade, I believe some of the parents were tagged in there. Lizette was tagged in there. Azriel was tagged in there. I think Geronda Pace was tagged in there. Quite a few of us were tagged in that dumb shit. Okay. And that was turned over to the feds. And they did use that. That was evidence. They found the IP address through that. And they realized that it was Richard Arline or Donnell Russell or both of them together. I forgot exactly what it was. It was a motion that was read a while back. I don't remember exactly what it was. So that's what he's being charged with. So now it says that based on conversations with Mr. Friedman and the government's review of filings in the United States versus Donnell Russell, 20 CR 427, Eastern District of New York, the government understands that Mr. Friedman previously had discussions with Robert Sylvester Kelly about representing Mr. Kelly in connection with other criminal proceedings in the United States versus Robert Kelly, 19 CR 286, Eastern District of New York, which we know was his racketeering trial in New York. Okay. And Mr. Friedman and Mr. Kelly entered into an agreement in principle for Mr. Friedman to represent Mr. Kelly. So, which agreement was in place for a significant period of time? So, they were just in agreement for an amount of time. Like I said, exchanging conversations and things of that nature. So, ultimately, the agreement came to an end because Mr. Kelly did not transfer any funds to Mr. Friedman for the representation. So he did not retain them. They didn't exchange money. They didn't make it official. They didn't sign no contract. None of that. Okay? Now, Mr. Friedman did not enter a notice of appearance in United States versus Kelly. So that just goes to show you he wasn't representing him at all, whatsoever. He just had conversations, consultations, probably, where they spoke about things, and R. Kelly was up in the air on who he wanted to hire, right? Now, during the trial in United States versus Kelly, the government presented evidence relevant to the racketeering charge, proving that Robert Kelly participated, okay, along with the defendant. Did you hear that? Let me repeat that again for the people who are slow in the back, the real slow bus people. I'm waving my light so you could see, so you can land the plane. Okay, the plane, highlighting. During the trial in the United States versus Kelly, the government presented evidence relevant to the racketeering charge, proving that Robert Kelly participated. Okay, that means he was in on it, guys. Participated. Okay, for those that don't know the glossary term definition, he was in on it. He did that shit. Along with the defendant, Donnell Russell, Don the Con. They did that shit together. Proven. in the Eastern District of New York. Okay? 9 counts. Thank you. In the same interstate stalking scheme with which the defendant is charged in the Eastern District of New York. The government presented evidence relevant to the racketeering charge proving that Robert Kelly participated, along with the defendant, in the same interstate stalking scheme with which the defendant is charged in the Eastern District of New York. And then over here in the footnotes, it says, the government in the Eastern District of New York case has filed a request for a Curcio hearing on the same grounds. In the 20 CR 427 Eastern District of New York, the electronic filing number, docket number 26. Okay. Now, as to the case before this court, the government also expects the evidence to show that Mr. Kelly was informed of the defendant's threatening communications after they were made. So R. Kelly knew about the shit. Okay? And Don called R. Kelly, like, listen, Kelly, we did that. That was done. We did it. We did it, man. We did it. We did it. We did it. Hooray. Yeah, we did it. Backpack. They did that. They did that. Yup. What? Yes, I was quoting Backpack. R. Kelly and his damn backpack. Yeah, he reminds me of Dora, Diego, and all of them. Okay. Okay, we got a whole bunch of them over there. They're hanging out of my trees and the bushes and the window and all types of shit right now. Anyway. So, now they're going to talk about applicable law, laws that apply, right? Basically. The Southern District of New York. He does. I got that paperwork too. So, I'm sorry, guys. I just so had to reach into my gummies. Them lifesavers are so good. They really are. Now, applicable law is law that's applicable, right? It's down by law. You down by law? Who down by law? I'm down by law. The Sixth Amendment provides a criminal defendant with the right to the effective assistance of counsel, which includes the right to representation by conflict-free counsel. Now, district courts have two separate obligations where counsel has a possible conflict of interest. Now, first, the district court has an inquiry obligation. Now, when it is apprised of the possibility of a conflict of interest. So, under which it must investigate the facts and details of the attorney's interests to determine whether the attorney, in fact, suffers from an actual conflict, like what happened with the Curcio hearing with R. Kelly in his case with Tricky Nikki. Okay. And the fact that she was dealing with the girls and talking with the girls and then having to defend R. Kelly when Azriel was the conflict, because Azriel was in touch with the lawyer who was representing R. Kelly. But then remember, Azriel wound up being a victim, a Jane Doe in the case. Because at first, when everything started, all they were going by was the travel tickets for Azriel. Now, those travel tickets for Azriel were given to Homeland Security. And Homeland Security used that as to charge R. Kelly with transportation of a minor. Now, Azriel was not cooperating at this time when it first started, but they used her anyway because she was a minor and he traveled with her across state lines. Remember, the girls did not bring forth charges towards R. Kelly. It was the government. The government is the one who brought in the charges, not the girls. Okay? So let's understand that. So the conflict of interest was that Tricky Nikki was in communication with Azriel. So she already knew some personal things of that nature about Azriel and R. Kelly's relationship. So she wasn't allowed during the Curcio hearing. It wound up being that determined to where they were not going to let Tricky Nikki cross-examine Joy if she decided to take in defense for R. Kelly and testify for R. Kelly. Miss Becker was not allowed to cross-examine neither one of the girls. That's where they left it at, because R. Kelly said, I don't have a problem with her remaining as my lawyer. I'm going to waive this conflict of interest. This is not a real conflict at all. In other words, that's what he's trying to say. So I don't have an issue. So we can leave her in here. So then the judge determined, okay, Donnelly said, Auntie Ann now said, well, then we're going to continue with Miss Becker as your lawyer, but she will not be allowed to examine these two witnesses. She can examine anybody else. And that's what happened. And she also stated that later on, you cannot come on appeal and scream and cry about a conflict of interest with this lawyer because you waived this right. You're waiving this as a conflict of interest. There is no conflict in your eyes. This is your right to be represented by the Sixth Amendment. You have a right. So are you sure? She asked him like a million times. He said, yes, 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 yes. And they left it be. So now Don Russell is complaining of the same thing. But it's between the lawyer and R. Kelly. That's the issue. So R. Kelly is the conflict. Got it? All right. Just wanted to break that down for the new people, the slow people, and everybody else in between that didn't understand anything I said and I read. And see what you guys are saying over here. Hey, Mama Rogers. What's up, baby? Hey, Cheeky Cheeky. What's up, Mama? Yo! Yo, Dre. What's up, Pa? What's up, Papito? Where's my Lynn? Where's Lynn at? Where's Lynn at? Did I say hi to Cheeky? Hi, Cheeky, Mama. Oh, Take R. Kelly. What's up, Take? Oh, baby, I cook roast beef. I cook. I get down. I get down. I get down, bro. I do. I do. I did have cooking challenges. I think I might bring that back. I got to reorganize it the way I planned it out. I got to do it a little different. I might just come back with that. And you will be here. Maybe you can compete with my girl, Unique. She's been dying to do a cooking show. She's been dying to do a cooking show with me. She's been dying to battle somebody. So maybe you might be the one. Okay. Does Don Russell has charges pending? Yes, I told you. Yes, he does in the Southern District of New York. I forgot exactly what it is. Um, Mama Rogers, we got all nervous. No, babe, don't get nervous. Mama Rogers, who you talking about? Tricky Nikki? That she didn't say anything in court? She was only taking notes. She said nothing at all. Okay. All right, so let's continue. All right. So now, as I said, we're going to go. Let me start here where it said district courts have two separate obligations where counsel has a possible conflict of interest. First, the district court has an inquiry obligation when it is apprised of the possibility of a conflict of interest, under which it must investigate the facts and details of the attorney's interest to determine whether the attorney, in fact, suffers from an actual conflict, a potential conflict, or no genuine conflict at all. Okay, then it cites another couple of case laws. Okay. Then it states that if any inquiry the court discovers no genuine conflict, if after an inquiry and the court discovers no genuine conflict, it has no further obligation. But if the district court finds after some inquiry that the defendant's attorney suffers from an actual or potential conflict, the district court then has a second disqualification / waiver obligation. So, under which it is required either to disqualify the attorney if the conflict is sufficiently severe or if the conflict may be waived. Now, remember in R. Kelly's case, it was waived, right? He waived it. Now, to conduct a Curcio proceeding, to advise the defendant of the ramifications of the conflict and obtain a waiver of any conflict from the defendant. And then it cites another state, United States versus Curcio. Now, at the other end of the spectrum, from a finding of no conflict, if the court determines that counsel has an actual conflict, that is so severe as to indicate per se that the rendering of effective assistance will be impeded, or is, oh God, analogous analogous to such conflict in breadth and depth, the court must disqualify the counsel. So, in other words, if it was so bad of a conflict, so severe to where the defendant would have to represent himself, okay, that rendering of effective assistance will be impeded, that's a problem. They will suspend the lawyer. They'll remove the lawyer. If it's really, really deep, and the court has to, have the Curcio hearing to determine if it really is. Then it says that in the Second Circuit, per se, conflicts have been found only in two classes of cases. And the circuit has repeatedly refused to expand the rule beyond those categories. So, where trial counsel is not authorized to practice law, and where trial counsel is implicated in the very crime for which his or her client is on trial. So, those are two examples of cases, okay, where there was conflicts, okay, within the Second Circuit, which is in New York. The Second Circuit is the appeals court, okay. And if between these two extremes, the court determines that the attorney suffers from a lesser actual or only a potential conflict, then it may accept a defendant's knowing and intelligent waiver of his right to conflict-free counsel and permit the defendant to be represented by the attorney of his choice. So, an actual conflict exists when during the course of the representation, the attorney's and defendant's interests diverge with respect to a material, legal, or factual issue or to a course of action. Okay. Then it says applying the standard derived from, and it cites a law, a case that happened. And then it says to show actual divergent interests. Speculation is not enough. They need facts. Speculation is not enough. They need facts. So, nor is a mere theoretical division of loyalties. And it cites another case. And it says that by contrast, an attorney has a potential conflict if the interest of the defendant may place the attorney under inconsistent duties at some time in the future. So the classification of a conflict as actual or potential can often be difficult or unclear. So through drawing such a distinction may be unnecessary, as most of both types of conflicts are subject to waiver. So that's why more or less R. Kelly's was able to waiver. He was able to waiver that, and there was not going to be a problem because in respect to the fact that it wasn't really nothing major. It was nothing major, nothing that the courts couldn't resolve, and R. Kelly was okay with it. So nothing there that was done was violating any of R. Kelly's rights. He wavered it. He said, listen, this is not a big deal. This is not a problem. The judge said, okay, well, you know what? In reality, you can waiver it because it's not really a big deal. This is a minor thing. It's nothing severe for us to disbarred someone from the case. It's not. So then it says, with respect to waiver or disqualification. Although a defendant may generally waive his Sixth Amendment right to a non-conflicted attorney. Now, R. Kelly did this. This is what R. Kelly did. He waived his right to the Sixth Amendment to a non-conflicted attorney. Okay? He can do that. There was no violation in that. Now, the essential aim of the Sixth Amendment is to guarantee an effective advocate for each criminal defendant rather than to ensure that a defendant will inexorably be represented by the lawyer whom he prefers, which means he has a right to choose his own lawyers. That's the aim of the Sixth Amendment, is to guarantee that he has lawyers to advocate for him as a criminal defendant. Okay? That's the point of the Sixth Amendment. It's not the point of ensuring that the defendant will be inexorably represented by the lawyer whom he prefers. That doesn't mean that. The Sixth Amendment aims specifically that it guarantees that he has an effective advocate, that he has a lawyer to represent him. That's it. And that the lawyer is conflict free. Now, the courts do, of course, retain discretion to reject a defendant's knowing and intelligent waiver when his attorney's conflict jeopardizes the integrity of judicial proceedings. Okay, they retain discretion to reject a defendant's knowing and intelligent waiver when his attorney's conflict jeopardizes the integrity of the judicial process. But absent such institutional concerns, courts will not assume to will not assume to paternalistic an attitude in protecting the defendant from himself. Okay? Absent institutional concerns, okay? Absent. Now, the courts will not assume to a paternalistic attitude. Okay, they're not going to baby you. The government is not going to baby you into protecting you from yourself. And although the defendant's choice of counsel may sometimes seem woefully foolish to the court, the choice remains his. Just like Donnie's like, I don't know why we're here, but it is what it is. But we need to be here because we have to do this by law. This is a waste of time, but we got to do what we got to do because we need to make sure that Mr. Kelly understands what is going on. And the choice is his. Nobody else. His. Then it cites something else, and it says that where a conflict is so egregious that no rational defendant would knowingly and voluntarily desire the attorney's representation, then the court must disqualify the attorney. Like we said, It has to be something so major, outrageous, out of this world, like not rational thinking. This can't happen. Okay. Now, if something like that goes on within a conflict, something so outrageous like Tricky Nikki sleeping with R. Kelly, she could easily be disqualified as the attorney. But they didn't do that. He waived his right. He said it was okay. I don't mind her being here. And then it continues to say that as such situations arise rarely. Now, such as where counsel is implicated in related criminal conduct. Like, where it's alleged that Tricky Nikki was in a scheme of things with Richard Arline and the whole bribery with Azriel, right? So such a situation like that arise rarely, right? Where the counsel is implicated in a related criminal conduct, or where counsel has a clear and significant personal financial interest in the matter that is directly contrary to the interest of his client. So in other words, he's trying to rob the client. Finally, the Second Circuit has detailed the procedures for a Curcio inquiry. At such a hearing, the court, 1, advises that the defendant of his right to representation by an attorney who has no conflict of interest. 2, instructs the defendant as to the dangers arising from particular conflicts. 3, permits the defendant to confer with his chosen counsel. 4, encourages the defendant to seek advice from independent counsel. And 5, allows a reasonable time for the defendant to make a decision. And 6, it also determines, preferably by means of questions that are likely to be answered in narrative form, whether the defendant understands the risk of representation by his present counsel and freely chooses to run them. So those are the procedures. They got to advise the defendant about his right to representation, who has no conflict. Also, they instruct the defendant about the dangers and the risk of doing what he's doing from certain conflicts. Also, they allow the defendant to confer with who he wants to have as his lawyers. And then also to encourage the defendant to seek advice from the independent counsel, which is like what they did with R. Kelly, and they had a appointed lawyer for him just for the Curcio hearing. Same thing here. And also allow the defendant reasonable time to make his decision. Okay? And everything has to be answered in a question form and answer form. Okay. Now, I'm so confused as to why he did this, because I think within this case alone, I believe he hired 2 lawyers, 2 different other lawyers. Like I think this is his 3rd lawyer. And Why would you hide? Like I said, I think this is what he did here is a stalling tactic. Honestly, I think this is what he did here. It's the weirdest shit, but I honestly think that that's what his strategy is. Um, Don's slick. He's slick. So, as a general matter, attorneys appearing before courts in the Southern District of New York must abide by the New York State Rules of Professional Conduct and Rule Point 1.7a of the New York State Rules of Professional Conduct. The rules, it provides that a lawyer shall not represent a client if a reasonable lawyer would conclude that either one, the representation will involve the lawyer in representing different interests, or two, there is a significant risk that the lawyer's professional judgment on behalf of a client will be adversely affected by the lawyer's own financial, business, property, or other personal interests. So Rule 1.7b provides that even if there is a concurrent conflict of interest under Rule 1.7a, a lawyer may represent a client if, one, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client, and two, the representation is not prohibited by law, and three, the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceedings before a tribunal. And four, each affected client gives informed consent confirmed in writing. It's a lot of rules. Okay. Okay, let's see how many more pages we got. All right. Okay, so now rule 1.8b, right, of the rules provides that a lawyer shall not use information relating to representation of a client to the disadvantage of the client unless the client gives informed consent, except as permitted or required by the rules. So although an attorney's duties to a prospective client are different than those to an actual former client, an attorney still generally must not subsequently use or disclose confidential information learned in the consultation with the prospective client. So basically, that's what they're trying to say here about R. Kelly and Mr. Friedman. Okay. Even though he a different than actual former client, the attorney still generally must not use or disclose confidential information learned in the consultation. Because remember, that's what he had, a consultation. R. Kelly didn't hire him, he was just in consultation with the lawyer. So, third of the law governing lawyers, okay, sections 15.1a of the NYR Professional Conduct 1.18b, it says that even when no client lawyer relationships ensue, right, that they don't actually happen, a lawyer who has learned information from a prospective client, from someone who can be a client, shall not use or reveal that information except as Rule 1.9 would permit with respect to information of a former client. Now, in addition, an attorney may not represent a client whose interests are materially adverse to those of a former prospective client in the same or substantially related matter when the lawyer has received from the prospective client confidential information that could be significantly harmful to the prospective client in the matter, unless both the affected client and the prospective client give informed consent. Okay, so the attorney cannot represent someone if, it goes with both people, unless the both of them let it rock. Now, a lawyer shall not represent a client with interests materially adverse to those of a prospective client in the same or a substantially related matter if the lawyer received information from the prospective client that could be significantly harmful to that person in the matter, except as provided in paragraph D. Example, if both the affected client and the prospective client have given informed consent, and they have to confirm that in writing. Now, thus, Mr. Friedman may not use or disclose information provided by Mr. Kelly, even if that information would be beneficial to the defendant. Now, in addition, depending on whether Mr. Friedman's agreement to represent Mr. Kelly created an attorney client relationship, notwithstanding that the agreement appears to have ended because Mr. Kelly did not transfer any funds to retain Mr. Friedman. It may nevertheless be a conflict of interest for Mr. Friedman to investigate leads, introduce evidence, or make arguments on behalf of the defendant that might tend to incriminate or cast suspicion on Mr. Kelly. Now, further, Mr. Friedman might not be able to provide independent advice concerning possible cooperation with the government to the extent such a decision could adversely affect Mr. Kelly. Now, further, Mr. Friedman might not be able to provide independent advice concerning possible cooperation with the government to the extent such a decision could adversely affect Mr. Kelly. So, Mr. Freeman, he can't say anything about what him and R. Kelly discussed. You know, um, it could provide not even further, it might not be able to provide independent advice. Okay, when it comes to possibly cooperating. So the government respectfully requests that the court inform the defendant of Mr. Friedman's potential conflict and conduct and conduct a Curcio inquiry of the defendant to inquire whether he wishes to waive the conflict, and if so, to ensure that his waiver of the conflict is knowing and voluntarily. So he knows what it is. Nobody's forcing him to make these decisions. He's doing them on his own. Give me 1 second, guys. Oh man, I gotta go check my Espérate, give me 1 second. Give me 1 second, guys. I'm putting you on hold. All right, sorry about that, guys. I had to wash my potatoes real quick, and I'm gonna get ready to stick them in the oven in a minute. Just letting them dry up. Okay. So, so now, as far as the discussion, Mr. Friedman's potential representation of Mr. Kelly is a prior representation of a trial witness are generally waivable. Just said that. Uh, all right. Accordingly, to the extent there is any potential conflict arising, according to the extent there is any potential conflict arising from Mr. Freeman's admitted representation of Mr. Kelly, it falls into the category of conflicts that are generally waivable by a defendant at a Curcio. So, attorney's representation of defendants who must receive trial was generally waivable after both defendants knowing and intelligently waived any potential conflict of interest. And in the conclusion of this is that for the foregoing reasons, the government respectfully submits that a Curcio colloquy is called for and submits the attached proposed questions for the court's use at the Curcio proceedings. Respectfully submitted, Damian Williams, who is the United States Attorney for the Southern District of going down to the Southern District of New York. Now, proposed Curcio proceeding questions. The government respectfully requests the court use the following questions in its examination of defendant Donnell Russell pursuant to procedures outlined in the United States versus Curcio. Now, in addition, the parties respectfully request that the court address Mr. Russell personally, seeking to elicit narrative answers from Mr. Russell and give Mr. Russell an opportunity to consider the court's advice and review it with independent counsel prior to accepting a waiver pursuant to the United States versus Curcio. Now, the intro questions are going to go as this. They're going to act on these questions. Okay? Do I sound low? Do I sound low? I'm going in and out as well. Okay. Guys, guys, can you hear me? There was my sound was, I don't know, it was on mute. I'm crazy. Oh Lord. Okay, let's go back, guys. Sorry, y'all. So basically, they were basically just telling R. Kelly. I mean, not R. Kelly. Um, the last thing that I stated was according to the extent there is any potential conflict arising from Mr. Friedman's limited representation of Mr. Kelly, it falls into the category of conflicts that are generally waivable. So again, being that this is not such a major thing, this can be waivable. The same thing with what happened with R. Kelly. It was waivable. It was nothing too big. So then it says that in conclusion, for the foregoing reasons, the government respectfully submits that a Curcio is called for and submits the attached proposed questions for the court's use at the Curcio proceedings. Respectfully submitted, Damian Williams, who is the United States Attorney for the Southern District of New York. Now, this is the proposed Curcio proceeding questions. So the government respectfully requests the court include the following questions in its examination of defendant Donnell Russell. Okay. In addition, the parties respectfully request that the court address Mr. Russell personally, okay, to seek illicit narrative answers from Mr. Russell and give Mr. Russell an opportunity to consider the court's advice and review it with independent counsel prior to accepting a waiver. Okay? So these are the questions that they're going to be asking. Do I sound better now, guys? Yes, thank you. Now, these are the questions that they're going to be asking Don. They're going to do intro questions first. They're going to ask him, how old are you? They're going to ask him, how far did you go in school? Do you currently consult a doctor for any conditions? Are you currently under the influence of alcohol or drugs of any kind? And they're also going to ask, are you feeling well enough to proceed with this hearing today? Then they're going to go to circumstances, okay, of the representation. So they're going to ask him, are you currently represented by Michael Friedman? The second question will be, I am advised that your attorney, Michael Friedman, has previously had discussions with Robert Kelly about Mr. Friedman representing Mr. Kelly, and that Mr. Kelly and Mr. Friedman reached an agreement in principle for Mr. Friedman to represent Mr. Kelly. Which agreement was in effect for a significant period of time? Ultimately, the agreement came to an end because Mr. Kelly did not transfer any funds to Mr. Friedman for the representation. So, given these facts, Mr. Friedman, therefore, has certain ethical obligations to Mr. Kelly. For example, Mr. Friedman may have privileged information from Mr. Kelly that could assist in your defense, but that he could not disclose because of his ethical duties. It is also it also is possible that another attorney could take a certain position with respect to your involvement or non-involvement in the crime charged against you, or your relationship with your alleged co-conspirators, including Mr. Kelly. Whereas Mr. Friedman may be ethically barred from pursuing such a defense strategy due to contrary information he may have obtained from Mr. Kelly. So, in addition, it might be a conflict of interest for Mr. Friedman to investigate leads, to introduce evidence, or to make arguments on your behalf that might tend to incriminate or cast suspicion on Mr. Kelly. So it is also possible that any advice that Mr. Friedman gives you with respect to how to proceed in this case may be influenced by a continuing duty of loyalty to Mr. Kelly. So, for example, Mr. Friedman may not be able to provide you with a completely independent assessment of whether you should pursue cooperation with the government. So, So Mr. Friedman would not be able to provide Don with a complete independent assessment of whether he should pursue taking a plea. Wow. Okay. Now, there may be other issues in addition to the ones that I've just described that can arise in which your attorney's ability to do certain things might be affected by the fact he consulted with Mr. Kelly in matters related to this case and entered into an agreement in principle to represent him. So no one can foresee every possible conflict of interest. Third, do you have any questions about what I have just explained to you? Can you tell me in your own words what you understand the potential conflicts of interest to be? Number 4, you have the right to be represented by an attorney who does not have any possible conflicts of interest in representing you at all stages of this case, including any plea negotiations. So if you proceed with your attorney, you will be giving up that right. Do you understand that? Question number 5. Have you discussed these issues with your attorney? Number 6. You also have the right to consult with an independent attorney who can advise you about the possible conflicts of interest that might arise if you proceed with your attorney. The court can appoint independent counsel at no cost to you. Do you understand that? So they'll, like they said, they will do like what they did with R. Kelly. They will appoint a court appointed lawyer just to defend him in this hearing. Number 7, you are not under any pressure to make a decision about this right now. You are entitled, if you wish, to a reasonable period of time to think about these matters or to consult further with your lawyer or with another lawyer before you advise the court what you wish to do. Number 8, having considered the way in which your lawyer's representation of you may be impacted, do you still wish to proceed in this case with Mr. Friedman representing you? 9, is your waiver of your right to conflict-free representation voluntarily and made of your own free will? Give me a second, guys. Sorry, guys. My son came over here to complain about the sugar-free pudding because, these kids like to eat all this stuff. And, it's no good for their weight. That my kids are getting big and they need to eat sugar-free stuff. Like I'm trying to give them better things. And my son's like, "Oh, this tastes like plastic. Oh, ow." And no, it don't taste like plastic. It's just taste buds. So now I'm forced to eat this pudding. Now, the next questions are going to be for Mr. Friedman. Okay, the first set of questions were for Don. These questions that they are going to ask now will be for Mr. Friedman. Now they're going to ask Mr. Friedman. Mr. Friedman, have you discussed the potential conflicts of interest with your client? And do you feel that he understands the possible risk of being represented by a lawyer with conflicts of interest? And is there anything else that either side would like the court to state or inquire about in this regard? And those are the questions that they will be asking. Now, also, they made a hearing date. So now, both Michael Friedman and another attorney by the name of Zawadi Baharani. Now, they are to attend the conference scheduled for May 18th. It was the 19th. I remember that. So they changed it to the 18th. So now the Curcio hearing is now scheduled for May 18th, 2022 at 12 p.m. in courtroom 705 of the Thurgood Marshall United States Courthouse on 40 Foley Square, New York, New York. So it's in Manhattan. Okay. The hearing will be where Ghislaine Maxwell's trial was. All right. So there you have it, guys. May 18th is Don Russell's hearing. It's not telephonic, it's in person. So May 18th at 12 p.m. Hey, Shaw, baby. Hey, Sharice. What's up, mama? What's up, Shaw? Oh. Shaw, what are you doing to me, Shaw? Are you the same people, Shaw, baby, and Daddy's girl? Hey, Charlotte. What's up, mama? Hey, Miss Showers, once again. Miss Rogers and everyone else in the chat. What's up, baby? What's up? What's up? What's up, ladies? Let's see what you guys are saying. Okay. Okay, you guys didn't say too much in the chat. You guys are just okay. Kayla says he's on that sovereign citizen duck and dodge tactic crap. You know, that sovereign citizen shit, that's wild to me. Hold on a second. All right. Okay. All right. I had to find the button there. Yeah, that sovereign citizen thing, I can't with that. Like, you ain't American. You're for me, you're get out of here. I can't with that. Okay. All right. Oh, yous are two different people? Oh my God. Why I thought y'all was the same people. Stop playing. Y'all look alike in your little pictures. Stop playing. I swear to God. Shaw, baby, and Daddy's girl, y'all twins for me. I swear to God, y'all look alike. Y'all look alike. All right. Well, that pudding was good, guys. Oh. Okay. Oh. Spoon is okay. So that's what's going on with Don the Con. Hey, Just V, what's up, mama? Breezing through, breezing through. I'm gonna take you guys out with this short little video. Guys, do me a favor, make sure you like the video, please. Thank you. Share and subscribe, guys. If you are not subscribed, please do so. All right. I'm going to take y'all out with a little something, something.
I just want to say, y'all need to leave him alone. That's not R. Kelly.
R. Kelly fans were the only ones talking outside a Chicago courthouse Tuesday. That's because a gag order is in effect as the long-delayed child pornography trial begins. Kelly is accused of videotaping himself having sex with an underage girl sometime between January 1998 and November 2000. The sex tape, all 27 minutes of it, was shown to jurors by the prosecution. Prosecutors maintain the girl in the video was as young as 13 when it was made. Kelly's defense team contends it is not Kelly on the tape. One of his attorneys spoke at length about a mole the size of a dime on Kelly's lower back that they say is missing from the man on the tape. The case is expected to last weeks. Kelly faces up to 15 years if convicted. Margie Zaraletta, The Associated Press.
Don't forget to hit the like buttons, guys. Don't forget, hit that like button. Hit the like buttons, guys. Hit the like buttons. And if you would like to donate to the channel, you already know Diva Divine Light, $, Cash App, Diva Divine Light. It is spelled the way it is on my name on the screen. Thank you for supporting. Y'all already know Diva Divine Light is out. Peace.